aspects. I'm going to look at criminal sanctions for competition violations, first of all. But I'm going to look at it in a general way. And then in the second part, I'm going to look at it in a specific context, and that is the UK context. So I aim to take about 40 minutes for the first part, thereabouts, 40 minutes for the second, and I may leave some time for questions at the end, but I'm certainly happy to answer any questions we might have during the panel session. So we'll start with the first part. So what I want to do here is to look at the rationale for employing criminal sanctions for competition law violations, and also provide some analysis perhaps of the difficulty with this particular type of activity, criminalizing competition enforcement. Now, at the outset, I should first of all explain that I'm talking about cartels. I'm not talking about all competition law violations. Now, I think I know, having read the legislation, that in Oman you have criminal sanctions for all types of competition violations. Well, I'm not going to comment on that. I'm happy to answer questions about that later, but I'm going to focus on cartels. And I'll explain what that is in a second, what a cartel is. I'm going to focus on cartels because most of the world that criminalizes competition law violations will criminalize cartels and nothing else. Or if there are countries that have criminalized other aspects of competition law, those other aspects are generally not enforced through criminal sanctions in practice. So the example would obviously be the United States. So I'm going to focus on criminal sanctions and cartels. Now, what does it mean, a criminal sanction? That's important from the outset too. What I'm going to talk about here is the idea of sending somebody to prison. So we're talking about imprisonment. Okay, so it applies to individuals, not to companies, in this particular presentation. Okay, now of course we can have criminal processes that apply to companies, and we can have quasi-criminal sort of administrative processes that apply to individuals and or companies that might lead to severe consequences for those entities, such as high fines. I'm not talking about that. I'm talking about the use of imprisonment. So I'm going to explain to you the general debate here. I'm going to go through the primary justification for this particular type of enforcement measure, and I'm going to outline some problematic issues. So what is a cartel? Well, this is a difficult one to conceptualize for some people, because if we look at the literature, we can see a cartel can sometimes be used to talk about the group of entities that come together to do something in a market that is unlawful. The cartel could talk about the actual agreement that is entered into between those particular entities. Or it could focus on the content of the agreement as such, what it is that they're going to do, for example, fixing prices. So I think at the outset, I should just give you a definition that I'm going to use throughout the presentation. We're talking here about an anti-competitive agreement, anti-competitive concerted practice, or anti-competitive arrangement by competitors. They are competing the horizontal aspect of the market to fix prices, make rigged bids, establish output restrictions, or share or divide markets. Okay, so that's what we're starting with. In terms of the negative effects, we can have increased prices, reduction in output, reduction in innovation, and very importantly, we can have what is known as deadweight loss. So we may have a situation because of a price rise due to a cartel that consumers that would have purchased the good at the competitive price do not purchase at the cartelized price. They're priced out of the market. They can't afford it, let's say. So that is unsatisfied demand that would have been satisfied in a competitive environment. And that's what we care about. Certainly that's what economists care about when we look at cartel activity. Now, cartels are prohibited across the globe. What's interesting here is that we have various definitions of cartels. More importantly, for present purposes, we have various enforcement techniques. And we have various sanctions that can be imposed for cartel activity. For example, administrative sanctions. There may be fines, for example, on companies that go through a process in front of a regulator. We might have criminal sanctions in the sense that we have a criminal process in front of a judge, we have a prosecutor, we have criminal rules of evidence, etc. And we have a criminal outcome, which may well be imprisonment if it's an individual, or it could be something else if it's the corporate entity, for example, a fine. So we have various types of punishment. Now, I'm going to focus on cartels. And I should say that within Europe, actually where I come from, cartel enforcement has largely avoided the employment of imprisonment. That's changing. So I'll give you a map later to show you how it has changed and how, we might want to think about how it will change in future. But Europe traditionally hasn't had this sort of enforcement. They focused mainly on the administrative side of competition law enforcement, unlike the United States. And the United States in particular, since, let's say, the 1980s, certainly from the 1990s, have been imposing significant criminal sanctions, custodial sentences upon those who are convicted of cartel activity. Now, there is a debate that's been going on. It's been going on in Europe in particular, I would say, for the last 15 years or thereabouts, and it's continuing. We have various entities, academics included, who have inputted into this particular debate. For example, the OECD Competition Committee, which stated in its second cartel report that its OECD member states should think about introducing criminal sanctions. It didn't say they should, but they should think about it because they thought that the criminal sanctions could indeed be a good deterrent to cartel activity. But there was a caveat. The caveat was that they should only introduce such sanctions if they would be in line with their social norms and legal norms. So there's an acknowledgement there that criminalization may not work everywhere. And it is jurisdiction specific in terms of the challenges and indeed in terms of these moral and social norms. But the DOJ, the Department of Justice, from the Antitrust Division of the Department of Justice, I should say, has been vociferous in its articulation of the importance of having criminal sanctions to deter cartel activity wherever the jurisdiction is located in the world. Now, this isn't just an academic exercise. We've already mentioned Oman, of course, but we have some countries in Europe that have introduced criminal sanctions recently, such as the United Kingdom. I'm going to get back to that jurisdiction a little bit later to show you some of the problems that can occur there. Sweden considered it, didn't go ahead with it for various reasons, mainly constitutional. Denmark has introduced them, and Finland apparently is considering them. I certainly wrote a report and inputted into that debate, but I don't think any sort of resolution has occurred. In any case, there are no criminal sanctions there at the moment. But other countries have indeed looked at this particular issue and have introduced criminal sanctions for cartel activity, such as South Africa, Brazil, Israel, and of course Australia, and recently New Zealand. Now, there are a whole host of difficult issues one could try to address here. And I've written a book on this particular topic that was published by Oxford University Press. If anybody wants to know about the book, I'll happily send an e-copy to you. So do come and get in touch with me if you want to read the book. But effectively, I looked at a number of different challenges, the theoretical challenges, the legal challenges, and the practical challenges of criminalization. Now, the focus was on Europe. But a lot of the arguments that were raised could indeed be applied to other jurisdictions. And here we could talk about the necessity of having such punishment. Why do we need it? Also, is it appropriate? What about those social norms that I mentioned? How difficult are they here? Also, we can talk about some of the practical difficulties. How do we actually design a criminal cartel offense that is not too broad, so that doesn't capture activity we don't want to see prohibited, certainly not subjected to criminal sanctions, but yet captures the inherent criminality of the activity? And again, we can link back to social norms and the importance perhaps of having a criminal law in this context capture the criminality that itself is captured by social norms that prohibit such activity, like stealing or deception or lying. Okay, so there are a number of different issues around implementation and design, which I won't get into now, but I will touch on some of these going forward. And I think those particular debates can have an impact here in Oman, because I have looked at the provision in terms of the criminal sanction, and it is very broad. And of course, I'm no expert on Omani law, but it just struck me as a rather unusual law in the sense that it was applicable not only to cartels, but other types of competition offenses. And therefore, there is an issue perhaps with design. So we'll get back to that. But we could also talk about human rights or fundamental rights. If we move from a process where, let's say, we have administrative fines, even on individuals, to a process where we could send those individuals to prison, one could argue that the rights those individuals have in the process should strengthen. In the administrative process, they may not be so strong regarding, for example, the right against self-incrimination. They might have to answer questions, even though they don't want to. But when it comes to the criminal setting, where indeed they're potentially facing time in prison, they would have a stronger right in that regard, potentially. And that all depends, of course, on your constitution, on your human rights guarantees nationally, but there is a debate about that, certainly, within the literature. So we need support here, we need public support, we need political support and publicity as well for the regime. Now I've put this on, sorry, the problem is when I press the button it doesn't change here, so I'm sorry about that, I'll try and remember. Okay, so this is important for you to look at. This is just to get an idea of the range of countries that have introduced criminal sanctions. So we can have a look here at North America, we have Canada and the United States. The United States is the global leader here, but we can go south and look at Brazil. In fact, not all the countries are on this map. I didn't create it myself. I took it from a US law firm's report, but it wasn't completely accurate. And I should add in a few others, such as Chile, where I was recently. They introduced criminal sanctions. They're thinking about it in Peru as well. We can go across the Atlantic and we can see South Africa has introduced them. I was in Kenya last year, the year before, and I realized they actually have criminal sanctions in Kenya as well, even though they've never enforced their cartel law. They've gone after dominant companies in terms of the process there, but they have criminal sanctions. Of course, Oman is marked, which is great, and we have a few in Europe, and we can go across to Australia. New Zealand should be added, and we have others such as Japan. So my point here is that this is not just about a European-focused debate, although you can see a good number of red countries in Europe. It's about the world, including this part of the world, including in particular Oman. Okay, so let's think about why we would want to have criminal sanctions in the first place. It seems to me, if we look at the literature, or look at any of the legislative processes that have led to the creation of criminal sanctions for cartel activity, the focus is on deterrence. So we're trying to stop cartels forming in future by punishing cartelists now. We can see the literature has a number of statements that would support this claim, such as criminal sanctions being the most meaningful deterrent to antitrust violations. Now, I could stop there and just move on to consideration of some of the challenges, but I want to give you a little insight into this particular argument, because it is a difficult one. There are a number of assumptions here. If we just say, oh, it deters, let's accept that and move on, we're looking at it perhaps too simplistically. Now, I'm not saying I accept all of these arguments. I'm just going to present to you what the arguments are, okay? So, in terms of the main approach here, let's assume, first of all, we have no criminal sanctions. We have a competition regime, but we have, let's say, administrative sanctions, or even just sanctions on companies, let's say. So no one goes to prison. Okay, so what we're going to do is we're going to assume that the cartelists, the undertakings, let's say, the first instance, the firms, are rational, self-interested beings. So they want to make profit and will only engage in activity if it's profitable to do so. So effectively, they'll weigh up the pros and cons. They'll think about how likely it is that they'll get caught, what punishment would be imposed, how likely it is that they'll make profit, how much profit will they make, and they will consider one against the other. Now, in that setting, if we want to deter activity, we need to set the punishment, let's say the fine in this case, at least equal to the expected benefits of the cartel. We must ensure that we discount that fine to take account of the rate of detection and prosecution. I'll give you an example. If, for example, I could break the law and make £100 from doing so, what should be the fine that should be imposed on me to stop me doing that before I do it? Now, some people might say 100, or at least 101. But that's not taking account of something that's very important here. I may not get caught. Maybe, let's say, 1 in 5 people who do the activity underlying that question get caught. So 20%. So to really take account of my cost-benefit analysis, you need to increase the fine by 5%. In other words, charge me a fine of £500 as opposed to 100. That's the economic deterrence theory at work. Okay? In its most basic form. Now, the interesting question for present purposes is what level of fine do we need in order to deter a cartel? Well, here we have to look at the profit and the length of time of average cartel, how likely it is that they'll get caught and also successfully prosecuted, to put it into the equation. Now, it's very difficult to do this. It's difficult to do this because, of course, we're talking about general level, and cartels, the specific cartels, may not work very well, may not generate much profit. Also, we don't know how many we're going to detect in any given time. We don't know what the rate of detection is because cartels are secret. We can only make an estimate as to what percentage of cartels we would catch in a particular time frame. So in any case, there are challenges there with the figures. But if we look at what we can rely upon, the established statistics and inputs, we can come to the conclusion that we're talking about somewhere in the region of 150% of annual turnover. So a very, very, very large fine. Now, this is the problem. That was created by Wouter Wills in a very influential publication a good number of years ago that was revised. He came to the same conclusion in terms of the size of the fine because other inputs had changed. But nonetheless, this is generally accepted in the literature. Some would go even further and argue that it could be up to 200% because we're not taking account of the rate of interest that should be taken into account if the cartel lasts a long time. Okay, so what's the problem? You might say just impose that fine. And if we could do so, maybe that would be the end of the matter. The problem here is that that fine cannot usually be imposed for legal reasons, first of all. We may have a cap, a legal ceiling on the fine to be imposed. So in Europe, EU level, we have a fine of 10%. That's the global turnover of the undertaking in all markets, not just the cartelized market. We could get rid of that, perhaps. There are good reasons to have it in terms of proportionality, but we could get rid of it. But if we get rid of it, and we try to impose a sanction of 150%, in order to deter cartelists, we're up against an additional problem here of reality. The company may not have that money. And what if it doesn't? What will happen? It'll be put into liquidation, which has an impact, negative externality on, for example, the employer, the employees, their families. Social costs, in other words, can be incurred. But also, we might have the increased concentration of the market in the short term. Let's not forget, this is a market where we've already had cartelization, so it could be concentrated. And concentration is one of the factors that can lead to cartelization. Okay, so what do we do then? Well, we could do nothing and impose a fine that we can actually get back from the company. But in doing that, we will not be deterring to the level we should. So the argument here is that we should turn to individual sanctions. Now, here's the important part. We could turn to individuals and impose a fine on the individual, nothing more. But the problem is that the individual is working to the company's benefit. The company is making profit from the cartel if it's successful. It's not like an individual is stealing from the company itself. The individual is stealing, let's say, from consumers and giving it to the company. So the argument is the company could be incentivized either to pay the fine or more likely to pay a premium to individuals within the firm that can cartelize that covers the chances of getting caught and having to pay that fine. So what we need here is a punishment that is non-indemnifiable, a punishment that cannot be paid by the company that benefits from the cartel. And that's where imprisonment comes in. The idea is that executives will not go to prison for their company. They will not take the risk of going to prison for that premium on their salary that may result as a result of the success of a cartel. Now, there are a number of problematic issues here. I've said before that I looked at this in particular through the lens of theoretical challenges, legal challenges, and practical challenges. I'm just going to focus on a couple of those challenges for present purposes. And I want you to think about how this might relate to Oman. As I said, I'm no expert on Omani law, and I'm happy to engage in a discussion about that. This is written at the more general level, but these challenges could be appropriate here. And if they are, we have to think about how you would actually rise to those challenges, how you can overcome any of the difficulties here. So I'm going to focus on three particular areas because these, in my view, are areas that are of relevance throughout the globe if one is going to follow a policy of cartel criminalization in any given jurisdiction. So the first one that I look at is protecting the administrative leniency program. I'll put all of it up there so that I don't have to keep turning. So I think we can start with some common ground. Cartels, particularly when they are subject to unlawfulness, are secret. Those who engage in cartel activity try to keep it secret. They don't want to get caught because they don't want to pay the fines that might arise, or at the very least, they don't want their customers to know that they're rigging the market in their favor, by the company's favor. So they keep them secret. Now, in order to get under that veil of secrecy in any cartel or anti-cartel regime, we should rely upon evidence from the cartelists. We want to try and get that evidence from them, for them to come forward and reveal the existence of the cartel. That's great evidence if we can get it. Now, often what a jurisdiction will do is introduce a leniency program. Now, let's just assume again we're in an administrative setting. There's no criminal sanctions to be imposed on individuals. We're in that setting, let's say. In that setting, we will surely want to create an administrative leniency program. Let's just say that we allow for the first company in the cartel to come to us as the authority, reveal the existence of the cartel, cooperate, give the evidence, explain how the cartel will work or worked. And in return, that company, the first one through the door, will get either a reduction in the fine that they would have been facing or no fine, immunity from the fine. Now that's useful because it allows us to create a tension in the cartel, to disrupt the workings of the cartel, because it introduced distrust between the members, each of whom will work for a different company, let's say, and each of whom may think about getting its company off the hook of a fine by applying for leniency. So we have this sort of distrust that's created. Now, what we don't want to do here is upset the working of that. If now, in addition to the administrative regime, or the regime against the company only, we introduced imprisonment as a possibility for any of the individuals engaged in the cartel, there's a problem. Who is going to come forward from the company, seeking leniency, giving all of the information, trying to get we have the activity being dishonest according to the ordinary views of reasonable people? And two, we have the defendant himself knowing it's dishonest according to those particular views. So an objective and a subjective element. Now the point here, we'll get back to in a minute, the point is that it's very difficult to establish that with cartels. In the UK, we're talking about 5 years as a maximum sentence. Okay. I'm going to skip this, but effectively what I had on the slide here was just underlining the point that the criminalization process in the UK was done in the name of deterrence. Now, they used dishonesty as part of the offence in order to underline the immoral behaviour of the criminalised cartel activity. But nonetheless, it was done for deterrence, to stop cartels forming in future. And we can see that from statements in the House of Commons and also from various policy documents. Okay, so if we're going to have this might apply here as well, I suppose. If we have a criminal regime in place, we're going to need to enforce that law in order to show we're serious about it, in order for it to be effective. And even if we have been enforcing it for a number of years, we want to continue enforcing it because we want to remind people it's still there. So how many prosecutions would we need in any given year? Anybody's guess, really. But in terms of the report that was prepared prior to the creation of the cartel offence, they talked about 6 prosecutions per year. Now, realistically, we might talk about maybe 1 high-profile case per year and not 6. Well, if we look at the record of the UK, between 2003 and 2011, we'll see it's a very, very poor record. Now, you might say, why is he picking 2011? I'm picking that because on that date, we have the beginning of the reform process. We have the start of a reform process that eventually changes the law. So between these 2 dates, how many prosecutions have we got that are successful? Well, 2 prosecutions, 2 cases. So one of these cases was successful. I'll get that in a second. And the defendants pleaded guilty. They weren't tried and found guilty by a jury. They pleaded guilty. The other was a disaster. The disaster occurred because effectively the prosecutor hadn't disclosed evidence that it should have done. Now, it didn't do that in any sort of suspicious manner. It was just simply incompetence. Documents that should have been disclosed were deemed to have been destroyed effectively, or couldn't be accessed in the database, but they could be. It turns out that they had to not only disclose them because they had material elements to them, but they had an awful lot to disclose. So as a result, the prosecutor at that time decided not to present evidence on the first day of the trial, which I think was fair. The other case, which was successful, happened in the marine hoses case, where effectively the individuals were arrested. The individuals who pleaded guilty in the UK courts were arrested in the US, and they entered into an arrangement with the US prosecutors. Effectively, they would go back to the UK, plead guilty to the UK offence, and they wouldn't be extradited back to the US on the assumption that they would serve the minimum term in the UK that would line up with what they were facing in the United States. Okay, so that was quite unusual. But anyway, the point here is that we didn't have too many cases. And what the OFT, the Office of Fair Trading at the time, was responsible for the prosecution, the cartel offence, which is now the CMA, argued was that the low level here was due to the element of dishonesty that was in the offence. So because of dishonesty and how difficult it is to prove, they didn't have a good enforcement record. That's what they stated. Now, the case that was a disaster that fell apart had nothing to do with dishonesty. There were no failures in front of a jury either that would be down to, let's say, or assume, dishonesty and the difficulty of proving it in front of a jury. It just didn't happen. But nonetheless, they said it was about dishonesty because in practice that's what they were facing when they were looking at cases and deciding which ones to prosecute. It was difficult, in their view, to get the evidence about that. So luckily for them, in 2011, a reform process was initiated that provided scope for reform. So this isn't just about the cartel offence. We had changes in the regime as a whole, quite significant changes, but it gave the opportunity to look at the cartel offence alongside those other changes. Now, before we get to that, I just want to show you what the record has been to date, because I gave you 2003 to 2011, just to give some more context. This is, I hope you can read that, but I can go through it very, very quickly. We're talking here about, in total, 5 individuals who all plead guilty. Okay? So, we've never had someone go in front of his or her peers and be convicted. It's all been through guilty pleas. We have had 3 prison sentences imposed and served. So 3 individuals have gone to prison for a total of 74 months between them. And that's it. Now, in terms of the different colours, all I want to outline are the top 2 cases. The top 2 cases occur after 2011, so after this reform process begins. But it's all to do with the old law. We've had no cases with the new law that I'm aware of. They're publicly available, from what I can tell. And those 2 cases led to suspended sentences in both instances. So it's a pretty poor record, one can argue. Of course, someone else could come along and say they were the only cartels that were in existence in the UK. How can we prove otherwise? And I guess that's just an inherent problem. Okay, so briefly through this, and then I'll get to a more interesting aspect for Oman. So what happens is that the UK government publishes a consultation document in March 2011. One of the chapters was about the cartel offence. And in that particular document, it put forward 4 options for change to the regime, change to the offence in particular. And they all involved the removal of dishonesty. So they didn't think it was a good idea to have to prove the cartel was dishonest in order to lead to conviction. Okay, but this is an important point for you. They got rid of it in all of the options, but there was an acknowledgement that in getting rid of dishonesty, the offence would be too broad. Even though it only focuses on hardcore cartel activity, price fixing, etc., it would be too broad because it would not allow for any form of efficiency defense. So they decided to rely upon something else. And those other things were, for example, prosecutorial policy, the creation of white lists, the proof of secrecy, or option 4, which is what I'm going to focus on, and it goes back to the earlier point about publication and notification, talking here about agreements made openly. So there was an option here for reform that, if introduced into UK criminal law, would allow for those agreements that are made openly to come outside of the criminal law. So if the cartel has, for example, published their arrangement after entering into it, it would not be a criminal offence. I thought that was a good idea. There were 115 responses to the document. 49 of them focused on the cartel offence. 33 of them said it's okay, leave it alone, let's see if it works. Of the 16 that remain, 3 entities agreed with option 4. The OFT, myself, and the research institute that I was part of at the time. The government, nonetheless, said option 4 should be adopted, and they said there was considerable support for it. And then we have the introduction of legislation that brings it into effect. Okay, it doesn't bring it into effect perfectly. There are a number of things that need to be commented on now in a second, but I just want to get you to understand the general idea here. We're talking about a carve-out of agreements made openly. So these sorts of agreements that are obvious to people out there, consumers, from day one, are not criminal agreements. Now, I said already it comes into effect on the 1st of April 2014. So this is current law. And it might sound great, but I'm going to explain to you how it's not going to work going forward. Okay. So the dishonesty element was removed. I think that's a good idea. I would not suggest to you to introduce into your law or into your prosecutorial policy necessarily this requirement to demonstrate somehow that your case in front of you demonstrates dishonest behavior, particularly where that dishonesty requires an objective assessment. In other words, most people in society would see it as being dishonest. If it's clear that's the case, then great, you might have a strong case. But it may be difficult for you to be able to do that, at least initially, because you may be trying to create a moral norm against cartel activity as you progress with your enforcement. The carve-outs of agreements made openly, I think, is a good idea. So here what we're talking about is when customers are given relevant information about the cartel before any sale, or where we have bid rigging, the person requesting the bids is told that they're collusive bids at the time of the bid, or we have relevant information being published in a specified manner. So relevant information here is the name of the parties, a reason why it might be a cartel, and the product market at issue. So it doesn't have to be a publication of a big agreement where commercial secrecy is violated, but just simply a small amount of information. It's enough to assess whether this is indeed warranted to publish. Okay, so we have a notification and publication aspect. Now, in addition to that, we have some defences that are brought forward. These were not part of the consultation. These were not part of the discussion in the House of Commons. They were introduced at a very, very late stage of the legislative process and were accepted without any debate. Now, 2 of them I can accept, but 1 of them is a very bad idea. So I didn't think I thought it would be obnoxious for me to come here saying to you, look, do this, it's great. The UK does it, without actually saying the reality. They've made a big mistake here. And I think that they've ruined what could have been a good regime with this particular addition to the final defence. And I'll get to it in a moment. I'm not exaggerating, by the way. I will put it on the board. Okay. So in order to evaluate this reform, we need to think about whether dishonesty and its removal was good, whether the carve-out of agreements is a good idea, and whether the defences that were added were a good idea. And I think these insights can be useful to other jurisdictions. And I have tried to present this sort of talk to other officials and respond to consultations that have come up. So, for example, I drafted a potential amendment to the New Zealand law when it was being discussed and sent it to the authorities there. Ultimately, they decided not to adopt it, but they were rather convinced about my other arguments in need of criminalisation, and they quoted me in the Parliament, which made me very happy, I have to say. So There are lessons to be learned here for other jurisdictions is what I'm trying to put forward. I have written a paper on this that was published in the Modern Law Review, and I'm happy to send that to anybody who wants to read it. Okay, so the first one is perhaps specific to the UK in terms of the test that needed to be proven, but I'll go through it very quickly because it might have resonance here too in terms of deciding whether to take a case because the individuals involved may demonstrate a violation of one of your moral norms. Well, there's a chicken and egg problem here. What they had to prove to get a conviction was that the activity, the cartel activity, was dishonest. In order to prove that, they had to demonstrate that most people in society, let's say, thought it was dishonest, whatever that means. But how do they do that when people don't know that much about cartels? The whole idea of introducing the criminal regime was to harden ideas, was to get people to rethink what they thought about cartels, to have enforcement of the law so that they could educate people. But you can't do that if you're relying upon that moral norm to exist explicitly already. So it's a chicken and egg problem. Okay. So the other point here is that if we allow for something like that to come into the law, dishonesty, it provides dubious sorts of defenses because of the nature of the activity at issue. Okay? We can have individuals come forward saying, well, actually, I didn't do anything wrong because all I was trying to do with this cartel was save the business, save the individuals' livelihoods within the firm. That's it. And that's the problem here. Okay, I'm going to move on from that. Now this gets back to the earlier point I had about legitimate activity, cartel activity. And I said that sometimes there may be cartels that are legitimate, or certainly legitimate activity might fall within a very broad definition of a criminalized cartel. So we need to be careful. And I said to you, one way of doing that would be with publication and notification. And I think that needs to just be underlined at this point again. If individuals that enter into a cartel that would otherwise be criminal genuinely believe that what they're doing is correct, let's say, would be efficient for society, shouldn't be criminal, in fact, maybe shouldn't be subject to any sanctions, then publishing, allowing for that publication or notification carve-out can help. Okay, because it can allow for the legitimate activity to go forward without overreach of the criminal law. Now, some here might say, if they're trying to be clever, well, all you have to do then as a cartelist, if you want to engage in unlawful behavior, is publish. Publish the agreement or notify the authorities, and there is nothing anybody can do. But that's not true. That's not realistic, because those cartelists you want to capture, those hardcore cartelists, will want to keep it secret because their customers will be dissatisfied. But also, if you have administrative or indeed even criminal sanctions that can face the company, not individuals, just the company, they won't want that to occur. They'll want to keep it secret so no other process, legal process occurs, or indeed private enforcement could be another thing to worry about, where the customers seek redress in the civil courts. So they will generally keep it secret, the hardcore activity. But even if all cartels were notified, that would be great. Because the whole problem with cartels is that they're secret. If they all become notified and therefore public, then your rate of detection increases. Therefore, you don't need to have a very high fine to deter. So you don't need to have criminal sanctions. So I think this is a very clever way of dealing with the problem. Okay, now, this is my central point for the UK regime that I want to underline. And it'll take a few moments and I should have time for questions. So if you'll bear with me, please. I know you've had two speakers and you're probably getting tired. If you've fallen asleep, it's time to wake up for 2 minutes, is what I'm saying. Okay, so what I'm saying here is that this carve out of notified or published agreements is not only good because it helps you deal with the legitimate activity, but it can also line up the criminalized behavior with immoral behavior again. So it gets back to our idea about unlawfulness being linked to wrongful behavior. Well, how? Well, the idea here is that by having those sorts of carve-outs, agreements made openly being carved out of the criminal regime, or if you wanted to, using prosecutorial guidelines to do that, you have this rough alignment between the criminalized activity or the activity that you're going to charge and deceptive behavior. But what is deception? Deception is rather easy to deal with. Deception is about the communication of a message where we have the intention on the behalf of the communicator to cause someone else to be misled, to cause someone to believe something that's not true. And then we have that person actually being misled, believing the untruth. So lying is a good example. If I said to you, actually, I'm 39 years of age, you believe me, you've been misled because actually I was 40 last week. Okay? So that's pretty straightforward. The difficulty, however, is when you don't have those positive statements of fact. When you have the cartelist not saying anything about the cartel. That's where the difficulty lies. So here's the argument. There are 3 scenarios relevant for deception. One is where the cartelist expressly states, no cartel here, haven't entered into a cartel. That's a lie. Or we have where the cartelist does not mention to the purchaser the fact that the cartel was in existence. That's tricky. And the final one is the obvious one, where the cartelist reveals the existence of the cartel. Now here's the argument. The first 2, A and B, we might have deception, a rough link with deception. They're being misled about the existence of the cartel to consumers. But the bottom one, we don't have deception because they're being made aware of the cartel. So if we allow for these carve-outs of agreements made openly to exist in law, we can line up the criminalized behavior with deceptive behavior, which is wrong, wrongful behavior. So we can actually give a sort of morality injection into your regime without too much difficulty, without having to rely upon definitions like dishonesty or having to try and figure out the sorts of things people think are morally wrongful. Most people would assume that lying is a bad thing, certainly when it leads to severe damage to an interest we all care about. Little white lies might be okay, perhaps. You say to your wife that dinner was lovely when it wasn't. It's hardly something that should be criminalized. But my point is that when we have business opportunity being affected, when we have consumers paying very high prices, we have this damage in society, and underpinning all of that is this communication that's misleading, then we might be able to argue that in fact it is something in itself that's serious. Okay, how much time do I have? Okay, I'll go through this very, very quickly. So the first scenario where the cartelist lies, does that occur? Ever been to a shop where someone says to you, you're buying some milk and it's been subject to a cartel, just so you know? Probably not. But if we're talking about bid rigging, for example, we might actually put in place a requirement that they sign something that states they haven't engaged in collusion when they're submitting bids. That's a good idea. The ICN recommended that. So we can say, well, actually, look, you've written this, you've lied to us, and you've submitted these bids. Therefore, it actually underlines the immorality of it. So if, as an authority, you are giving any advice to policymakers about, or to others about procurement processes and what they should entail, I would say to you, it's a good idea to have a written statement as part of that, if possible, so you can underline the immorality of the behavior if those individuals are later caught. Okay, the second scenario I'm going to look at is where we have this active, or we have this passive sort of attitude. We have a message communicated. Here are my goods. They're for sale. You can buy them. There's no statement about the non-existence of the cartel. There's no admission about the cartel. It's just simply goods are for sale. How is that deceptive? How is that misleading? Well, it might be misleading if the companies know that consumers are assuming there's no cartel. Now, if it is unlawful to have a cartel, the consumer might be just giving the company the benefit of the doubt. The idea that without proof of unlawfulness, I'll assume they haven't broken the law. In other words, I'll assume this is competitive. They might be cynical, fair enough. They might be cynical and assume companies will do whatever they can get away with. Okay, but what if they fill in consumer satisfaction surveys where they go, the price is actually pretty good this year, I'm happy with it. But it turns out it's a cartelized price. Well, in that instance, we have the cartelist knowing that consumers are making a mistake, that they've been misled. Now, you might say this is all very abstract, and of course an academic would stand up here and argue this. But this actually changed the law in the UK for a short period of time. In a different context, it wasn't a cartel offence, it was a common law offence of conspiracy to defraud, and the courts accepted it. It was later overruled, but nonetheless, there's a strong argument there. And I think it's one we should accept, perhaps, if we're going to try and line up very roughly criminalised cartel activity with deception. I'm not saying you need to prove deception. I'm just saying that this lining up helps you underscore the immorality of the behaviour. Now, of course, this is stating the obvious, perhaps. The third situation does not involve deception, because where do we have an intention to mislead when they've told the truth? Or indeed, how are consumers going to be misled when the painful truth, the truth they don't want to hear, has been told to them? So my bottom line here, and this is directly to officials who might be involved in determination of prosecutorial policy, is that it is good to link, either through legislation or at the very least through prosecutorial policy, criminalised behaviour that you're going to seek to punish with some moral norm. And I think the moral norm against deception is a very good idea, because you can do it easily with these notification or publication type carve-outs. That doesn't require very much in terms of action from the authorities. You don't have to look at the notifications if you don't want to. The idea is to allow for the potentially legitimate cartels to be okay, and these other ones will be kept secret and therefore deceptive. Okay, so we'll end on a funny note, perhaps. I'm going to go back to the defences that have been introduced in UK law. And there were two defences that were okay. You could prove on the balance of probabilities that you had no intention to conceal from customers or the authority. It would be a defence. Okay, it links again with deception. No intention to conceal, no deception, perhaps. But look at this one. Have a read of this. This is the third defence. It is a defence for an individual charged with an offence under Section 1881 of the Enterprise Act to show that before the making of the agreement, he or she took reasonable steps to ensure that the nature of the arrangements would be disclosed to professional legal advisors for the purposes of obtaining advice about them before their making, or as the case may be, their implementation. So what does that mean? What's the bottom line here? Well, bottom line here is that you've got no obligation whatsoever as a cartelist to take the advice. So if you're going to enter into a cartel in the UK after the 1st of April 2014, and you want to be clever about it, you go to your lawyer, make sure it's your own lawyer, not the company's lawyer. So the lawyer owes you the duty of privilege and therefore can disclose the conversations later in court with your consent. Go to your own lawyer, explain what you're trying to do, and you will get a defence, because you've taken reasonable steps to get advice from the lawyer, even though you don't take it. In other words, you can create your own get-out-of-jail-free card by simply going to your lawyer. Now, I'm not exaggerating. That's what it states. And the prosecutorial guidance that came out after the creation of this offence doesn't disabuse me of that particular position. Okay, so this is the law. And we could easily argue, as I've just had, that we can short-circuit the whole operation of the offence by allowing for these get-out-of-jail-free cards to be produced. Now, the lawyers that are listening don't have to disclose the cartel or the arrangement of the plans. In fact, if they were to disclose it, they would be disbarred. So what do? Well, I'm not going to go through what some people have argued, because I think it's a nonsense. I'll just go down to the bottom line, which in my view is that we should abolish this particular defence. Now, as an academic, I am put under a little bit of pressure to get some impact from my work, certainly in the UK in recent years. And this is something that I genuinely believe, but it's something also I would like to see occur. So I have sent responses to consultations that are related to consumers and to cartels, advocating this abolition. I've spoken to people in authority about this. Hasn't happened yet, but I have argued for it in my Modern Law Review piece, and it's on record. And I hope one day they will, because I think going forward, this sort of defense is a nonsense. So please don't look at the UK and think this is a good way of doing it. We'll allow for this to become part of our law, or if we see this in action, we won't prosecute. Okay, so that's the bottom line in terms of the presentation. I think dishonesty should have gone. I think the carve-outs are a good idea because it lines up the offence with immoral behaviour. It allows for legitimate activity to be taken out of it, but don't have one of those defences created, in particular the defence of getting advice from lawyers. Okay, I'll leave that on the board for a second. Thank you.
Thank you, Professor. We actually have 5 minutes, and then we'll have the broader opportunity later for questions and answers. So maybe a question before lunch. Anyone interested? Probably hungry for lunch, or Doctor?
Thank you very much, Professor. It's not a question. I would like to. I agree with you that dishonesty, it's difficult to prove. I agree with you. Thank you very much. Thank you for this point.
Okay, thank you.
Professor, I have a question about the carve-out. I guess in many jurisdictions, suggesting carve-out or the approach might seem like self-incrimination in one way or the other. If I look at the Omani law, and I'm no way a legal expert, but my interpretation is the law here incriminates a lot of activities that fall under cartels. And how might we go about incentivizing that? So having leniency might work much easier with the current law, where we have, but that is still a matter for the court. But in our center, in the Competition Protection Center, how might we get to that level of someone might declare a certain type of agreement, especially that agreements are often seen as secret and et cetera, et cetera. So what are your thoughts on that?
Thank you for your question. It's a very, very difficult question to give a very strong answer to, because the issue here is getting access to the information and prosecuting successfully. And in order for leniency to work, let's say if we want to have a policy of leniency to get that particular evidence and then successful prosecutions, you need to convince those in the cartel that absent the leniency policy, you would be able to get them anyway. Because no one's going to come forward unless they think they will get caught. So you need to have the ability to catch them and also have severe sanctions facing them before they'll come forward with any evidence. The severe sanctions can be taken care of with legislation. Let's just assume you want to go after the company, so you have significant fines as a possibility, and you have the process in place that respects your constitutional requirements. Okay, that can be done. The difficulty, however, is convincing the cartelists that there is a risk they'll get caught absent the leniency. So how do you convince them that's the case? Well, you have to rely upon other techniques not related to leniency. One example might be you rely upon bounties. So you pay people for convictions effectively. So they can be people maybe that are on the peripheries of the cartel. Maybe you have the secretary who is organizing the meetings, who's privy to the information, who might even have access to documents that you want to incentivize to come forward by paying out quite a significant sum of money if the prosecution were successful on the basis of at least some of that evidence. Now, they have that policy in the UK, they have that policy in South Korea, and they have it in Hungary. And I think it's something to think about. But you also need to think about how else you're going to discover the cartel in the absence of bounties, because it may not be, the most successful sort of policy to rely upon that alone. So you need to think about what sort of techniques you can use to get behind the cartel. And it's not just about running human agents through leniency. You might be able to, you might be able to wiretap with criminal sanctions. You might be able to get evidence through that sort of covert activity on behalf of the authorities. But of course, you're up against human rights guarantees in that context as well, and you're going to probably need to have sufficient evidence already to be able to obtain the permission to get these taps put onto the phones and what have you. So I think it's a very difficult thing. Personally, it's always surprised me that leniency works at all on the basis of the theoretical claims, because I think it's so difficult to get that evidence to make a credible threat for leniency to work that it shouldn't really work. And in fact, some people are concerned these days that the level of leniency applications in Europe is declining significantly. That may be behind it, I don't know. But it's a very difficult thing to do. I was in Kenya and I had the same question posed to me. What do we do to get evidence absent leniency? And also, how do we get people to come forward with these leniency applications? So the leniency application in theory is easy. You need to be a credible threat, absent leniency that they will actually be caught. And then, of course, you need to communicate that particular policy, etc. But the bottom line is I don't know. Maybe Richard has some pointers as an authority.
Any other question? I think we're on time, so it's 2 o'clock. And I would like to propose, we had an hour for lunch and prayer break, but if you prefer, we keep it to a 30-minute lunch break, and then we come back at 2:30 for another hour of an open discussion. So that is a suggestion. I'm open to anyone objecting to it, but this is something that I think would give us more time for discussion and hopefully open up the floor for those who didn't have a chance to ask questions. So we'll start lunch. The buffet will be served just across the hall, and then we'll have lunch here, I believe, in the same hall. So thank you all again, and so we'll see you in half an hour.